here and thank you for your patience. So I see it says it's now streaming. I see myself. Hello. And we just need to make sure we're recording as well. So Rita, do you want to go ahead?
Good evening, everyone. My name is Attorney Rita White. I am the president of the Black Women Lawyers Association. I appreciate you for coming to this event, this very important event, given the fact that we have a lot of new law coming into play, such as the expungement law. So this is a very important presentation that I hope all of you pay attention to, because we have a lot of people in our community that really are suffering, trying to find jobs, trying to find work, trying to become what they want to be, but there was nothing really available for them in the court system to be able to take them out of their conviction to move forward with their lives. I personally am a criminal defense attorney. I've been practicing as an attorney for about 20 years, 10 years as a prosecutor, 10 years as a defense attorney. And I've seen so many cases where really people slip through the cracks based on not being able to move away from their convictions. I look at it as that people do bad things, but that doesn't mean they're a bad person and they don't have a lot of potential to make good for this community, our community. So what this is the Harriet Tubman event. And we do this bi-yearly. Every 2 years, the Black Women Lawyers puts on this event, mainly to honor a very, very big, one of the biggest pioneers in our century. Her name is Harriet Tubman. She died March 10th, 1913 in Auburn, New York. She was a bondwoman, an American bondwoman who escaped from slavery in the South to become the leading abolitionist before the American Civil War. Harriet Tubman was considered a hero because she worked at the Underground Railroad and also helped many slaves escape out of slavery and be able to live freely. One of her quotes were, "I freed 1,000 slaves. I could not free 1,000 more. If only they knew they were slaves." So this is a very important special top issue that we always want to embrace during Black History Month. And really, this should be embraced year long. There's many pioneers, there's many wave makers, there's many basically generational makers that have really paved the way for all of us. So we should really always respect and really give credence to all of these heroes and individuals that are no longer here that have really made a way for us, people of color. So I'm going to ask you some housekeeping matters, that if you can respectfully keep all of your devices on mute, unless you are a panel member that is going to be presenting at that time. Next, I would like to also, we wanted to bring a special part of this actual event, to bring in someone who's going to sing some very, very special music. I know her personally. She is a very local and national renowned singer. She sings locally and she's very well known. She's a jazz singer. And I had a chance to meet her at an event where we were able to sing together. I'm sure many of you know her. She sings professionally at Baker's Lounge in Detroit, Michigan. I would ask that you come visit Baker's Lounge, because that is one of the highest local and national renowned jazz, basically jazz, places that people can come to actually listen to very talented musicians. So with no further ado, I would like to introduce our vocalist who is going to sing some special songs relating to this Black History Month, and it is Audrey Northington. You're muted.
Oh, Miss Northington, you need to please unmute yourself.
Yes.
Thank you so much. I'm honored to be in the presence of such greatness, especially among Black women. The first song, Sing Out for Liberty. The words of the stirring song were written by the poet James Weldon Johnson to commemorate the birthday of Abraham Lincoln. The words were set to music by J. Rosamond Johnson, the poet's brother. And later it was adopted as the NAACP national anthem. Lift every voice and sing till earth and heaven ring. ring with the harmonies of liberty. Let our rejoicing rise high as the listening skies. Let it resound loud as the rolling sea. Sing a song full of the hope that the present has brought us. Sing a song full of the hope that the present has taught us. Facing the rising sun of our new day begun. Let us march on till victory is won. This song means so much to me because it's the very first song I taught all of my children for 32 years in Detroit public school systems and Highland Park. The first song was Do Re Mi. The second one was Lift Every Voice and Sing, followed by the Star Spangled Banner. But this is a song that is about us, and it embraces all races. Thank you.
Amen.
Amen. Oh, Miss Northington, are you going to sing the To Be Young, Gifted, and the other song?
Yes.
Okay.
Young, Gifted, and Black was written in 1969 by Nina. Hello?
I wanted to say she's also considered the scat diva.
Okay, I'll give you just a tiny bit of that. You know, when you think about putting jazz to songs that has so much historical meaning, but I'm going to get into that. 1969, Nina Simone wrote this song. Later was adapted, a gospel version by the Queen of Soul, Aretha Franklin, To Be Young, Gifted, and Black. And of course, this is another song that I had to teach my children, my choirs, to sing. To be young, gifted, and black. Oh, what a lovely, precious dream. To be young, gifted, and black. Open your hearts to what I mean. When you're feeling real low, there's a great truth that you should know. To be young, gifted, and black, that's where it's at. To be young, gifted, and black. Oh, how I've longed to know the truth. There are times when I look back and I am haunted by my youth. But my joy of today is that we can all be proud to say, to be young, gifted, and black. That's where it's at. Doom, doom. That's where it's at. Doom, doom, doom. That's where it's at. Thank you.
Thank you, Miss Northington. That was amazing. That was awesome. So everyone, my name is Attorney Robin McCoy. I'm the Vice President for Black Women Lawyers of Michigan. I actually have a dance and theater background. So when Rita suggested that we bring in Miss Northington, I said yes, yes, and double yes. And just amazing. I'm like, we're gonna have to probably book you for a separate concert, okay? Because that was beautiful. So ladies and gentlemen, we have this, it's our Harriet Tubman Social Justice Forum. As Madam President has indicated, this is a biannual event. And today we're examining Michigan's expungement law. And we have two distinguished panels. We have panels of state reps, and we have some panels of legal experts. So I'm going to announce the panelists, and I'm going to turn it over to the moderators. So we'll start with the first panel. We have state representatives. So if you could raise your hand when I say your name. I know, again, we normally would be doing this stuff in person, but hey, COVID is with us, but we adjust, okay? We're learning the technology, we're working it, y'all. So Representative David LeGrand, who has been championing this cause, I met him last year on a panel with State Rep Ronnie Peterson. So welcome, Representative LeGrand. And then we have former Representative Sherry Gay Degnogo, who is now on the Detroit Public School Board, and who is very instrumental with this legislation, specifically the One Bad Night legislation. And I linked up with Sherry and the late State Representative Isaac Robinson last year. Because we normally do expungement forums with the lawyers and the judges, but last year I said we need to start adding the state reps, state senators, so that we can have more of a dialogue and to perfect these laws to make them more friendly to the public. And we have State Representative Tanisha Yancey, who is amazing. I know her from working with her at the juvenile court. She's a lawyer, prosecutor, state rep extraordinaire. So who has been, championing these causes. We've been joined by State Senator Jeremy Moss. If you could raise your hand. Yes. Okay. And then we have State Representative Jewel Jones. If you could raise your hand. Yes. Okay. And so, yes, we're going to have two panels today. We're going to have the panel of state reps, and then we're going to have a panel of judges. I'm going to give a shout out to Judge Deborah Thomas, who is the expungement queen, who I wouldn't be here if it wasn't, she recruited me. She recruits, I consider myself an expungement princess. I guess that, and so she recruits attorneys to come and help her with these programs, and it stuck with me. I've been doing this is going on my 7th year. We go around to the community talking to folk, and we also we have Attorney Stuart Friedman. I know Jocelyn is going to get into more of the details with his introduction, but Stuart is my go-to person. I consider him an expungement expert. And so we have moderating today, we have Attorney Tanisha Davis, who is also on our planning committee for this event. And we have Attorney Zenita, who is Clipper, who is with us as well. So I'm going to turn it over to our wonderful moderators, and folks, you can put questions in the chats. We have some questions that we have for the panelists as well. And if I'm just going to give a caveat, just like we do in person, if it's something pending or private, you may need to get the information from the lawyers and have a separate consultation. So this is, we don't want to be getting into pending issues, things like that. With us being on social media, you can put your questions in the chat, either this chat or Facebook chat. So I'm going to turn it over to Attorney Davis and Attorney Clipper.
Good evening, everyone. Am I echoing?
Yeah, you may have it.
Yeah, I think I am. Good evening, everyone. My name is Attorney Tanisha Davis. I am a practicing attorney in the Metro Detroit area. I practice a number of things, criminal defense, as well as family law. Always been very interested in the issue of expungement. I want to say greetings to this esteemed panel here. We're excited to be here today to discuss this issue. This is a very educational forum. We are educating ourselves as well as the community about this new sweeping expungement law. So there are questions that we have regarding implementation of this law, eligibility of this law, as well as a number of other issues that we've seen as we've reviewed that. So I'm just going to ask, in terms of our moderating this, there's a lot of individuals on the panel here. So in asking the questions, if you all can keep your responses between 1.5 minutes and 2 minutes, so we make sure that we get everyone who wants to respond to these questions. Each of the individuals have had a role in this law and developing it. So we want to make sure we get everybody's responses as well and be respectful for everyone who's on the panel. So I'm going to turn it over to Zanita, who will jump off the first question.
Good evening, everyone. So we know the law has changed where previously you had to wait to 5 years after you've been released from probation, whatever was later. Now we have the 7, 5, 3-year tier. Can you guys explain that a little bit more of what made you guys decide to do the 7, 5, and 3-year tier for the rep?
And anybody,
so for the representatives, I would say
Tanisha.
no,
Rep David LeGrand, Rep David LeGrand, or Rep Yancey. Rep LeGrand worked as a power lead in the House on this package, so I defer to him.
I'll take it then. I just didn't want to jump in here. So everybody, not everybody in this call is an attorney. So I'm going to start with my elevator speech on this, which was all the attorneys know we had an incredibly narrow door for expungement that very few people could walk through. And we've done a large expansion of the width of that door and all kinds of aspects to that. And former Rep. Gata Ignogo had a piece of that, and there were some other pieces to that puzzle. But the other really exciting thing we did was the automatic component. And they're both exciting, right? It's exciting to have more people be eligible, but the other thing is that everyone should I hope remember about this is with our existing laws, with the old narrow door, even with that old narrow door, only 1 out of 16 people who were eligible would walk through that door. And there are reasons for that, right? Not knowing what the law is, maybe hesitation to bring up something in your past you don't want to talk about and revisit. Maybe you don't have access to somebody who can help you. But the fact is only 6% of people who were eligible were getting expungements. And so a big piece of this was we now are going to be a national leader because we are the first state in the country to do automatic expungement for some felonies. Now, as far as the 3, 5, and 7, and this is going to be a recurring theme you hear from me, and I'm just going to be straight with the group here. We have a Republican majority in the House, and we have a Republican majority in the Senate. What that means is that all of the panelists you have on this call are Democrats. And so this journey really started in earnest basically 2 years ago. January 8th, I put together a work group and I said, look, I think we can do this. Let's start. And we got the Attorney General, defense lawyers, representatives, a whole bunch of people in the room and started working on this package. But you aim high legislatively, but sometimes you get chipped away at. And so there was a lot of negotiation that happened in the course of getting this bill done. So I will just tell you one of your questions, for example, on the question of violent felonies and eligibility and restriction of eligibility for people who had done violent crimes. I spent my summer vacation in 2019 just going at it hammer and tongs and pushing the relationships to the limit to try to get more eligibility in this package. So, if you want my personal opinion, and I think all of our panelists would say, the faster we could do expungement, the better. So I don't think there's any great reason to wait 7 years, except that we had to come up with things that would be palatable to the Republicans. And when I say the Republicans, if you look at how this passed, it looks like it passed with overwhelming support, but you got to remember, of the people in the legislature, only half of them are Democrats and half of them are Republicans, roughly. But the Republicans control things, so we had to get half of that half. But even then, former Speaker Chatfield had a principle. He didn't want to lose more than 15 Republican votes, or he wasn't going to put something up for a vote. And on some of the pieces of this legislation, there were 14 no Republican votes. So we barely got this through. And that's a long way of saying, would I rather have it be shorter than 7 years for multiple felony expungement? Absolutely, I would. But this is what we could get done. Now, the one thing I'm really excited about is we can now get misdemeanors expunged after 3 years. And that's a huge deal. That's going to be a much quicker process. And we all know, like, there's lots of people out there who, you know, they look at a police officer funny and all of a sudden they got a misdemeanor, right? So getting faster expungement for misdemeanors is a big deal in terms of giving people hope, getting them back on their feet, getting them out, you know, succeeding in life. And the stat I keep telling people over and over again is if you clean up somebody's criminal history, their household income goes up 24% overnight. So what we all accomplished is maybe the biggest anti-poverty thing we've ever done in the state of Michigan. And it was absolutely a team effort. And, you know, so I am undyingly grateful to all of my colleagues who worked on this so hard.
Thank you, David. Would anybody else like to weigh in on that question? Or I'm going to move on to the next question. Any of the other panelists?
No, our colleague covered it from the beginning to end. You can ask the next question.
All right, so I'm going to direct this next question to Attorney Stuart Friedman. Mr. Friedman, we oftentimes see clients that are charged with felonious assault, felony firearm, or felon in possession and felony firearm all at the same time. The statute would bar the setting aside of these convictions. Can you talk about what the legislative intent was in barring those offenses?
I think that my predecessor just did. It was unfortunately all about politics there. There were certain offenses that they couldn't get through, but I think that felon in possession can be set aside. I think it's under the definition of violent offenses, but I believe that they can be. I think that some of the ones that are in there would fall under the one bad night exception too, as long as you turn around and prove that these events happened out of the same transaction. Violent offenses are tricky, they're politically difficult, but one of the things to the people who are in this situation that I'm going to remind them is that we probably have the burden of proof to show that they're all out of the same transaction and that you need to save documents. Quite often, a lot of these documents are lost and you are in a difficult position about having to reconstruct things after the fact. If anybody disagrees with me, please weigh in.
Well, I want to be clear. I do want to jump in here because you're right. I mean, felonious assault is expungible. So is felony firearm. So is felon in possession. So I'm not sure what you're reading. I actually went back and so all of those are expungible. There are limits on, and I wish that their limits were less restrictive. But again, there's sort of a Venn diagram thing. As I explained, the bigger group of eligibility is the ones that need judicial review, and that, you know, that's easy to sell because a judge is going to look at the record and make a judgment call. And so our automatic is more restrictive. And so maybe that was what people were thinking about. But in fact, you know, felonies up to 10-year felonies are automatically expungible also.
Okay, so
I just want to clarify with that question.
I was going to clarify that. Go ahead.
Yeah, that question, when we're talking about, because what we'll see a felon in possession, felonious assault. So you'll see those together. But with the one bad night statute, it says you can't have an offense that has a gun. And so I'm like, so the intent of that question is that we as criminal defense attorneys, we're seeing a package with felonious assault, felony firearm, felon in possession. But the way the one bad night law is written, with it saying, you know, it can't be a gun, then there's going to be a lot of people who have those charges, those package of charges together that are not going to be, they could only have either one felony within, you know, the 5-year time frame, and then they'll have to wait to get the second felony after the 7 years. So that's what I asked the question is why that was put. And I don't know if that probably could be best directed to former state rep Gag Dignogo about why they put the restriction about weapons in there.
So again, and this is one of those instances, and thank you, Rep. LeGrand did do a great job answering that. the politics of negotiating a package like this out, and I have to give due respect and pay homage to Judge Deborah Thomas, as we stated earlier, who's been the pathfinder of criminal justice reform and expungements throughout Michigan. And when I reached out to her to get her help and just kind of get an understanding, her first response was, "It's not going to happen. We've been pushing for this for years." And I'm like, "I know, but right now I believe the Republicans want to find a path forward, but we can't get everything that we want in an environment where we don't control the House or the Senate, and that is still the same today." And so leaving out, we had to negotiate down to the bare bones of what the Republicans saw as a possibility. No, this does not cover the lion's share of issues that we have, especially those with possession of felony firearm, because I put a bill in prior to this in dealing with the mandatory minimums with a felony firearm every term that I was in the House, as I did with a bill like this, but it was reconstructed because when you don't control or hold the gavel, you have to take any advancement that you can. And so one of the questions I think you'll ask later is, so what will need to be done to improve these bills over time? Hopefully, when we gain more seats in the House and the Senate, then you will see the evolution from a Democratic intentionality of advancing these bills to include more. Right now, we're at the ground floor, ground zero of advancing some relief for our returning citizens, but this is not utopia. And so we want to advance more, but we had to start where we could. And it took a lot of work, a lot of wrangling. And I applaud Rep. LeGrand, who was the vice chair of judiciary, and all of the judges who weighed in to help give us guidance. But you don't just get what you want. You get what you can for your community when you're at the table with the people who control the gavel.
Now, to put that in context, and I don't want to
jump in real quick, David. Keep in mind that a few years ago when expungement legislation passed, it was 1 felony, 2 misdemeanors, right? And so that was part of that thing. That happened then as well. It happened then, and it's gonna continuously happen until Democrats actually have the gavel and we can do the things that we want as opposed to compromising to get what it is that we can. So we had 1 felony, 2 misdemeanors that they increased in a couple terms ago. And then this term we have expanded it much broader than that. And then next term, hopefully we can even get more. We're already, David and I have already started talking about expungement bills that got left out of the package that we all have, that hopefully we can have a part 2 this term.
That being said, I don't want the tone to get too negative here. Let's remember, we are now, with the passage of this, we're a national leader. Like, no one has gone farther than Michigan now. And my best guess is this package is going to help something like 1 million people. I mean, the estimates were more than 100,000 people just in the city of Detroit, just on marijuana charges. I mean, we're talking about a bill package that's going to mandatorily mean judges have to scrub people's now misdemeanor marijuana charges. Now, could we have gone into delivery charges? In a perfect world, we could have, but we're going to be able to help something like 100,000 people just on marijuana misdemeanors, let alone all the fact that we're just like all kinds of people. I used to have people call my office and I had to train my receptionist to explain, to tell her the criteria, because 90% of the people who called me for help weren't eligible. So we're going to move from 90% ineligibility to maybe 20 or 30% of people we can't help. I don't know how it's going to come, but like, this is a big expansion. So I don't want the tone to get too negative here. Yes. Would all of us want to go farther in lots of places? You bet. But it's pretty amazing that we got as far as we got.
I'll make an additional point there. Look at where Michigan has come from to be this punitive state of mandatory minimums, and legislators who thought about what more punishments can we tack on to misdemeanors and felonies. And now we're finally heading in the opposite direction of what relief can we get to people who have paid their debt to society, have been rehabilitated, and how can we provide them opportunity to get out of the criminal justice system? We're not all the way there yet, but I can speak for myself and my colleagues here, Rep. LeGrand, Rep. Yancey, and Rep. Gay Danyogo and Rep. Jones, we've always been on the side of criminal justice reform. And at long last, our colleagues on the other side of the aisle have joined us on this effort. So they're on this journey with us, and we're not all the way there, but we've reversed course from where we've been.
Thank you.
And there's still lots of work to do. Like, pull my leg and I'll give you a long list. There's a lot of stuff to do. We got to do cash bond reform. We got to do sentencing guideline reform.
We need to do that fleeing and eluding two charges. Yep. One expungable, yep. One is not. And LeGrand left me off the last bill, but we'll make sure we get it on this time.
And I want to lift up Representative Yancey here a minute. She and I have really been holding the line in judiciary last session. We're going to do it again this session, because a lot of legislators come in and they get upset about something and they want to make it a crime. And that's the road to mass incarceration. And historically, on average, every session, Michigan makes 45 new things, crimes. And we have been holding the line in judiciary, and that has way stopped. So I'll give you an example that Tanisha and I both fought on. A nice meeting rep came in and wanted to make it a crime for a parent to get on a school bus without permission of the driver. And we were like, we are not making parents into criminals if their kid forgot their lunch. Like, you want to come up with, so we fought and we won on that. But that's there are like 20 examples of that from last session. And Tanisha's my sister on this. Like, she does not mess around. So I just want to lift her up on that one.
Take the next question.
Tanisha, this question is toward you. Because I heard you speak about it a while ago. But one of the big things that this new law does expand is for the motor vehicle misdemeanors, which we know many in the city of Detroit, as well as Jewel can comment about this as well. In Inkster, we've seen citizens not be able to get expungement because they had so many driving with a suspended license. So this will open that door. And so have you explained more about what motor vehicle codes are being expungible now?
So first of all, there was a time or a myth that had gone on when I first got to the legislature. We talked about the fleeing and eluding one, where I was told, oh no, we can't expunge any traffic because of the federal dollars that we get from the Department of Transportation on a federal level, and it would eliminate the funding that we receive on a federal level. We came to find out, and I don't know, I know that for my staff, we reached out to the department, you probably did as well, LeGrand, but wait.
I just want to shout out here. This is weird, okay? I'm a Democrat, but I want to give a shout out to a Republican staffer. His name is Hassan, and he is the guy who did the research and came back and said, you know what? That's a bunch of BS. That is an urban myth. They've been saying that. Every Secretary of State, whether they're Republican or Democrats, been saying it for 30 years, and it's not true. That was the moment where we're like, hallelujah, let's go get this.
So,
it was Republican.
Yeah, I also want to say, I understand. I look at this is a nonpartisan issue. So yes, we have invited Democratic representatives, but we're open to inviting the Republicans and asking them, what do we need to do to make this more public friendly? And also, we have Representative Jones. I wanted to hear, I know you have been very engaged with this and talking about youth issues. So would definitely want to hear you weigh in on your, what your thoughts are about expungement. And even, I know there's been some expansion with juvenile expungements as well.
I'll make sure I hop right in. I know Representative Yancey was finishing something up. I'll hop in right after you, sis.
Thank you. So, and I know that my office had also investigated and did some research to find out that that it wasn't accurate, that we were just kind of making things up as we go along, apparently, and no one really does the research. But just to answer your question, some of the things that were not expungible before that will be expungible will be driving without a license. Most of the traffic offenses that are not DUIs, and I would just say that we are working and did actually pass out of the House a DUI, first time DUI to be expungible, but it was actually vetoed by the governor's office. I was approached today about that very same bill to make sure that we can get that run through again this term. So one time, we're hoping for the first time DUIs to be expungible. I will be a sponsor of one of the bills. I feel like it's it's definitely something in my wheelhouse. My father was killed by a drunk driver. It will eliminate, though, anyone who caused death or great bodily harm or anything of that nature. But a first-time DUI, where it's just simply a DUI, will be expungible this next go round. And Graham Filler is a great person to have on it from the Republican side if you'd like to have anyone else on in the future, because he is our chair of our Judiciary Committee who is advocating for especially for that bill for sure. He was disappointed that it got vetoed, as were we. But those are some of the things that we are looking at and some of the things that have already been done.
Awesome. Okay, and just for the audience too, again, you guys know I'm a college professor. DUI is driving under the influence or operating while intoxicated. I know Judge Thomas has a background as a teacher too, so we just want to make sure we explain, because we're lawyers. A lot of us are lawyers. We speak legalese, but we want to make sure the public understands. So
thank you for that.
Thank you. So my next question I'm going to direct to Mr. LeGrand. When you started out, you were speaking very highly of this automatic provision that this new expungement law adds. It sounds like a lot of bureaucratic backup. So can you explain how the automation of the expungements will happen? And what efforts will need to be made either from the individual or from the agencies in order to make sure that happens the way it needs to?
Well, that's a great question. I mean, we're really just at the start, right? So legislatively, what legislators do is they mandate. So we're like, this has to happen. The first thing that happened was state police came along and said, it's going to cost more money than the gross national product. So we said, well, wait a minute. And so we kind of got, we got into real fine detail on how much it would actually cost to do an automatic architecture. But the great news is, and the governor and Lieutenant Governor Gilchrist really went to bat on this piece of it. He was watching to make sure at the end of last session that they would pass a funding bill to make sure that there was funding in place to build the automatic architecture. Now, it's going to take longer to do the automatic, because you're right, we got to build those databases, make sure the court systems talk to each other. All that's got to happen. So we gave a 2-year timeline for that to happen. And so I'm not an IT guy, right? But the IT guys are going to have to talk to the judges and the court people, and all that's going to have to happen. It's going to be a process. But the good news is there's real money behind it. We allocated, and I don't know if one of my colleagues can help me here, it was either 35 or $50 million. It was real money. So, and that happened right at the end of the.
Can you say that again? I apologize. I didn't hear your. Kind of got it flipped.
Anybody else remember? I don't want to get it wrong. It was either 35 or $50 million. It was real money to build up the architecture for this. So that means we've got sometimes you can pass bills, and if there's no money behind it, you may as well have not done anything. So when I got to the legislature, the first thing I did with some colleagues was pass a bill saying we should use restorative justice as the discipline in our schools and not the school to prison pipeline expel you mechanism. And so we've got a law in the books that says that all public schools should use restorative practices. Problem is there's no funding behind it. So like if there's no dollars to go along with the good you want to do, it can just fall to the wayside. So the money is there. And that was, I give so much credit to the governor's office and particularly to Lieutenant Governor Gilchrist for really watching and advocating and holding the line on that. And they were like saying, we're not going to do X unless you make sure you pass funding.
Perfect. Thank you. Thank you, David, for responding to that with such clarity. I just want to ask, just as a follow-up, there's a portion of the new law that talks about a fund. Is that the fund that you're referring to?
I think so. We might want to look offline and see exactly what we're talking about. But yeah,
that was the appropriation bill that was passed out of the Senate and then out of the House. The last bill that we actually passed during the last legislative session, which was in fact a Christmas miracle. Because without it, it would have been a moot point for automatic expungement.
Yeah, you should have seen how happy Sherry was that day. Yeah.
Question. I know that there was a couple questions in the chat. Let me see here.
I want to bounce back to Representative Jones, because I know he wanted to talk about the laws that affect our juveniles and our younger generation. So.
Well, I definitely hop in. I'm super glad to be on this call. First and foremost, I'm super excited about the work my colleagues done. As you may know, I wasn't actually a part of the physical package. I co-sponsored some of the legislation. I really hopped on because of the late great State Representative Isaac Robinson. We were doing a lot of work around the marijuana expungements, and so he had got me on with House Bill 5120, which is now PA 189, part of the package, and really it was. You know, I'm super committed to clean up these records. I personally believe no one should have to continue to pay for something that they already paid back. And so, you know, huge shout out to David LeGrand for working on this, as well as Sherry and Tanisha, Jeremy, and many others. But I'm super committed right now to post-conviction work. So the expungement process comes afterwards, but I've been working a lot as of late with people who are still locked up, who might be parolable lifers or people who've been serving time for a very long time. And so I know we're getting off this call. So I just want to throw this bone out there ahead of time. I'm going to be calling on you all because I know you all are committed to helping people become whole and getting people back on track. I would really love to have some help from the subject matter experts to get some of these people on track to get out from behind bars. Because we have a lot of people who have extremely wonderful skills and talents who can really help move Michigan and the rest of our world forward if they're granted a second chance. And so that's why I'm here. That's why I work on this kind of stuff with my colleagues, because I think that we all make mistakes and we all should have a chance to get back on track.
So if I could jump in for a moment right after Rep. Jones, and just want to applaud him. It's about teamwork. While everybody may not have had their name on a bill, what he was able to do, and he's being very modest about it, utilizing his social media skills. He and former Rep. Isaac Robinson pushed to make sure that bill was included in the package. And let me tell you why this is important. We can have forums, expungement reform initiatives, and you name it. But if we don't reach the people who need these reforms, then our work is in vain. And so we got to have people who have the youth thinking outside the box to get to the people, because you heard Rep. LeGrand say earlier, the University of Michigan put out a study that less than 6 or 7% of the people who currently qualify for expungements actually apply. So when all the tools are up, when the AG put her page up, the city of Detroit has their clean slate page up. I put my website in there, myfreshstart.com. We have to work collaboratively and use outside 21st century skills to get these links into the hands of our community members that need them, and then do the work through Black Women Lawyers Association to get it done. So just wanted to shout you out before you jumped off, Rep. Jones, to say thank you. You got about 1 million followers. He was the one who helped us get plugged and get our Instagrams certified. So thank you for the work that you do. Even though your name wasn't on a bill, you certainly helped to ensure that Rep. Isaac Robinson's bill was included in this package.
And if
Yeah,
I can
I
make
want to shout out Representative Jones as well, because
Awesome.
he's been sending folks my way for myself and some of my colleagues to try to directly help them with expungement, with getting expungement as well.
And if I can make an additional note there, because it was around this time last year that Rep. Yancey and Rep. Gay Danyogo and I participated in an expungement clinic hosted by Rep. Kyra Bolden, who's the state rep for Southfield. I'm the state senator for Southfield. And so it's on a lot of us to think creatively how to get this information and meet people where they are. And so I think we're going to continue to host community forums and community events, hopefully in person when all this nonsense is over, and host expungement clinics to allow people to better understand what is the new process and what is the process toward expungement. And so lean on us as legislators to put that call out into the community, but we're going to lean right back on you to participate and get the word out there as well. So yeah, it was about a year ago that we hosted our first expungement clinic, and we're overdue for another one here in Southfield and in other communities.
And I'm just going to do one every single year in the Grand Rapids area. I'm partnering with the NAACP. We've already got it booked, planned. We're doing it in a big park, so we can do it outdoors. And I hope to God that we'll actually have enough vaccines that the community will be vaccinated by the summer. Maybe now that we've got a president who doesn't think we should gargle bleach, we'll have some progress on vaccines.
The Detroit Caucus will also be hosting an expungement fair, an outdoor fair. We're organizing now, as it was already stated before. The law doesn't go in, the changes won't go into effect until April of 2021. So we want to wait until those people are actually eligible. But I do see some of my sorors on here. I know Delta Sigma Theta does a lot of expungement fairs. We have Lakeshore Legal Services that does a fair, expungement fairs, but this information is definitely available to you. I see another question in the chat. I'm not trying to take your roles, Anita, but just to piggyback off of that, the question is whether or not funding is given to the federal, the defender's office. I'm sorry, the state defender's office. And as of right now, that funding is not for we don't have any funding for them to facilitate expungements, but we did increase, I believe, dollars for. LeGrand, help me out here. We're not federal defenders, but state defenders.
Public defender's office.
I'm sorry, what was the question?
The funding for state public defenders to do expungements. We don't have funding for that, but we did increase their funding last year, and I can't remember what it was.
MIDC.
Yeah.
Thank you.
I mean, one of the things, and again, look, if everybody in this call cares about justice, one of the things we really got to push for is people have representation at arraignment. That's going to make a huge difference, because I see so many people, it breaks your heart when you see somebody standing in front of a judge and they don't know what the right thing to say is. They don't know how to advocate for themselves. They don't know how to talk about their financial situation. They don't know they don't know how to frame things. And like having lawyers at the arraignment is, I think, potentially a game changer. That and the fact that we got to burn the cash bond system to the ground, but that's another thing, I mean, I've been working for 5 years, so like, don't get me started on cash bond. Oh, it's so messed up. Like, why are we using a wealth test when we keep people in prison? Like, it's completely immoral. We should be looking at safety. We should not be looking at how rich you are. Rich sociopaths get to go home, and poor non-dangerous people don't get locked up and have CPS come take their kids and lose their jobs and their housing. Sorry, that's not what we're talking about. But we got to get this done like yesterday.
No, that's fine. That's why we're here. It's all about criminal justice reform. I did put in the chat about Project Clean Slate. So they do expungements for Detroit residents. And then I put in the chat too the information for Lakeshore Legal Aid. They do expungements for people who are indigent. And yeah, I would definitely say, I know you guys mentioned some of your expungement events. Let us know so we can help spread the word, because knowledge is power. There's scripture that Hosea 4:6 says, my people perish for lack of knowledge. And that's part of why I do these kind of educational programs, so that people can get more knowledge. I mean, with these new laws, I know Judge Thomas will talk about too, like the lawyers need to understand it. So we need to understand so we can help the people, so.
Do you want us to move forward? I wanted to direct a question to Representative Yancey. As we were talking, you mentioned about a bill that I think you indicated that you had sponsored that had a portion in there that the governor vetoed because it included DUIs. Can you discuss what is the issue about alcohol-related offenses that has barred those offenses from expungement, and oftentimes even a provision or statute that could assist a first-time offender? What is it about the alcohol-related offenses? And I know there's been some discussion here about the politics involved, but can you speak to that, please?
Yes, what I want to make sure that I am very clear of, though, is that I cannot and will not speak for the governor's or for the governor vetoing the bill. I'll allow for her, her to explain why she vetoed that bill. But I can tell you that some of the things that I've heard about from Pam, like the Prosecutors Association of Michigan, is that they're very reluctant on allowing those driving offenses that are driving under influence offenses to be expungible, because I want to say that they say that for every person that is caught with a DUI or with under influence, driving under influence, it's 800 times that they have done it before they're actually caught. And so we are, and I'm a former assistant prosecutor, but I also can relate to second offenses because of my own personal testimony as well. And so while I do not agree that because you think that someone may have done this 800 times before they were actually caught, that they should live with this on their record for the rest of their lives. Either catch them 800 times or don't hold against them, right? So that's the argument that has been made by the Prosecutors Association. And then, just that it's not necessarily political, which is why I started out by saying my father was killed by a drunk driver. I completely understand that it is a very serious. However, if you cause injury or harm or death, you won't be able to get those expunged. So we're not talking about the person who, killed my father, right? And even still, I believe he even deserves a second chance. It's bad enough that he ruined an entire family, right? So why ruin his entire family too? And it took a lot of growth for me to get to that point, because really I didn't feel that way 13, 20 years ago, but I do now. I think that everyone deserves a second chance, especially when it's really a mistake. I mean, a lot of us have, or we know someone who, there's a TED Talk I want everybody to be able to see, and I'll try to remember what it is and put it in the link, where, they're asking how many people have gotten behind the wheel of a car after a couple glasses of wine, and people raise their hands. How many of you have ever gotten into a fist fight with a family member at Christmas dinner and people raise their hands? At the end of the questioning, a lot of hands were up, like 80-90% of the crowd's hands were up. And they said, well, keep your hand up if you've ever gotten arrested for those things. And 85%, probably 89% of those hands went down, right? And so we can't keep, throwing stones when our houses are made out of glass. I can relate, and most of the defense attorneys on here can also relate, but we have to make sure that people who have never gotten caught relate as well.
Can I add some additional comments, because that was something that we also worked on the Senate side too. So to give a timeline, the expungement package that we're talking about passed the Senate and the House in the fall. And was presented to the governor. And at the time when we were debating this in the Senate, there was a conversation. Why are OWIs, DUIs left out of this expungement package? And one of my colleagues from the UP, a Republican from the UP, Ed McBroom, spoke out and said, I'm voting against this whole package, not because I don't agree with the expungement, because you haven't extended that grace and that mercy to those who have OWIs and just can't, and it follows them for the rest of their life. And so he, in the fall, introduced a standalone OWI bill. I supported it. I spoke out on the floor in support of this effort too. And because that was a standalone piece that hadn't gone through 2 years of vetting by itself, it passed in that lame duck session. The governor has been public about this. She has stated, and I've talked with her directly about this, that she felt like it was due to have an extensive hearing on this issue as well. So I know that Rep. Yancey and others are going to continue to lead on this effort, which I fully support. And I think that's the next package that's going to get its due hearing. It did pass in the legislature in both chambers, but the governor really wanted it to be more vetted, I think, in the committee process, because those OWIs, they follow you forever. And that can influence your schooling, that can influence your job opportunities, because Rep. Gay Danyogo and I have worked to amend the definition of good moral character. When you apply for a job that the state licenses, if you have an OWI from years and years and years ago, you will fail the good moral character test in order to get a job license. So another thing that we've worked on is reforming the definition of good moral character so that your criminal conviction, whatever it might be, in and of itself, cannot be pointed to as a reason to deny you a job license. And these OWIs are following people. This could have been years ago, an isolated incident, a non-violent OWI, and still this is going to impact somebody's ability to go to school, to get a job. And so we're tackling this on all ends to reform this.
So and let me jump in here. A few things. First of all, and Representative Yancey is absolutely right. One of the things that drives me nuts is if somebody gets wrongfully convicted, you'll hear people say, well, they were probably guilty of something else. That logic of like, well, they were probably driving a bunch of times and didn't get caught is the same kind of logic. Like, use the justice system, but don't act like if you convict people, they probably did something else bad and it doesn't matter if you convicted them wrongly. Second of all, I have a really hard time when we're talking about expunging a drunk driving, we're not talking about the police not knowing about it. You can, if you expunge an OEYL first and you go drive and drink and drive again, you're going to get charged with a second. That's not what this expungement's about. It's about liberating people to have job opportunities. It's about not having them like lose an opportunity to rent a house. It's all of that kind of stuff, because really publicly available records of criminal convictions are about stigmatizing. They're about ostracizing, putting the mark of Cain on people. And that's, the whole dynamic. Representative Jones said it earlier. He's right. Like at the end of the day, we have this phrase out there, paid your debt to society, but keeping people's criminal records on their backs forever means we were just kidding when we said that. We didn't really mean that you paid your debt. You just got to keep paying forever.
You get sentenced to a lifetime of unemployability. Exactly. You get sentenced for the crime that you've committed, but you also get sentenced for life for unemployability, yeah. And that doesn't make sense.
And of course, it's also...
Or if you run for office, you get sentenced to making sure that they bring up what you did at 17 to 18 years old, 30 years later, 20 years later. I ain't that old.
Well, my sister Tanisha here is the only one who I know who's courageous enough to talk about her personal history without hesitation when this comes up. And that is so powerful. And I cannot thank you enough for having the courage that you have with this stuff, Tanisha. Like, you are my sister. I love you for this. Like, you are courageous and fearless. You're my hero.
Awesome. Well, thank you for your response on that. Certainly appreciate everybody's feedback. Zanita, do you want to take the next question?
I was making sure we don't have any questions in the chat as of now. Any other questions in the chat? Unless anybody has a last minute question in the chat they wanted to add.
If no one has a question, I just wanted to throw a question out there for any of the panelists to answer regarding, there's a portion of the statute that also permits a person who's owed restitution to file a motion to have a conviction reinstated. And did I read that correctly?
Yeah, you want the war story? I'll give you the war story. You want the war story?
Yes.
All right, well, here it goes. You want to know how sausage is made? You got to think about this. Things don't just have to pass by a majority through the House or a majority through the Senate. It's also got to get the green light from the Speaker of the House or the leader of the Senate, because they set the agenda. So they can pocket veto any issue they want by just leaving it on their desk and not letting it come up for a vote. So for example, I had a financial disclosure package last session. I had 63 co-sponsors. So a majority of the members of the House signed on to that legislation that they were down with it, and it never saw the light of day. Now, things can also get pocket vetoed, and you can ask any of us on this call who are representatives, they can get ignored in committee. So whatever committee something gets referred to, if it doesn't make it out of that committee, you're done. Now, to make it even more granular, so expungement, we're through the House, we get through the House Judiciary Committee, we get through the House floor vote, then it goes to the Senate. You got to get through the Senate Judiciary Committee. Now the Senate Judiciary Committee has 8 people on it. Seven. It has 7 people on it. 2 Dems, 5 Republicans. Now, one of the basic principles of any majority committee chair is they don't want to do something without a majority of their own caucus, their own people. So forget about the Democrats. Now you got 5 Republicans. You got to get 3 out of those 5 Republican votes, or that thing's not going to go through. So going into that hearing, Senator Lucido was down with this package. He was a yes. Senator Vanderwall was down with this package. He was a yes. Senator Johnson was a no. He was, well, pass technically, but that's the same thing as a no. And Senator Runstead was a pass. So that meant the whole package, the whole project came down to one person's vote. That was Senator Barrett. Now, I had a lot of conversations with Senator Barrett. I was getting, Senator Lucido was dragging me in the room to answer his questions. He had security go get me from the hallway at one point during testimony to bring me in to answer questions. I wasn't like supposed to be testifying, but like he got backed into a corner, and so he like got security to drag me into the room for this. But ultimately, we put that language in, and it took me hours of conversation with Senator Barrett, because he had this idea in his head. He couldn't get past the idea that expungement was a reward, and we didn't want to reward people who still owed money on restitution. And I said, Tom, where do you think restitution comes from? It comes from income. Where do you think income comes from? It comes from having a job. How do you think people are going to get a job if they can't get expungement? And if they had money, they would have given it to you at sentencing because it would have helped their sentence. And if you're all this way down the road now, years later, and you still don't have their money, you can't get blood from a stone. They don't have money. If they had money, if their people had money, you'd have it by now. Like, so I don't know what magic money you think is out there, but whatever. So at the end, we put this in so that theoretically a victim, if they're upset about this because they didn't get all their restitution and thinks, oh, David LeGrand's got a trust fund, he's been hiding his money, they can make a motion to come back in and retroactively claw back. I don't think it's going to happen maybe 2 times a year in the whole state, right? Like, we're going to help 1 million people. If I got to like back off 2 people so we can help 1 million people so I can get this package passed, I will make that deal. So that is a sausage making story, but that is what went down.
Thank you, David. I think we probably need to move on to our second panel. I want to, on behalf of Black Women Lawyers Association of Michigan, I want to thank every panelist who's spoken and offered some information regarding our understanding or better understanding of this expungement law. Thank you all for your hard work and putting it together and getting it on the floor and passed. So certainly appreciate everybody. I think Jocelyn Fleming is going to introduce our next panel.
Thank you very much.
And I invite any of you that are able to stay and chime in, you're welcome to stay. Yes, and thank you. And this is just the beginning, y'all. So, look for me to call you, might have you do some individual interviews. And so, because this is very good and it's informative.
Well, thanks for having us. Really exciting.
I'll stay, but my camera is going to be turned off so I can eat dinner now.
I was just thinking that.
All right, hello everybody. My name is Jocelyn Fleming. I'm going to introduce our second panelist. Actually, I love that you just mentioned the camera thing, because on Facebook, everybody who has their camera on, you're being showed. So if you're not on the panel, it would be a great thing for you to turn off your camera right now. We should only have 4 people showing, and plus our 2 moderators, if that's okay. All right, so with that being said, we have 4 panelists. These are legal experts. So there have been a lot of questions in the chat about how does this law work? Well, this is the panel that's going to explain it to you. So we have experts. We have Judge Deborah Thomas. So there have been a couple of questions expressed to judges. She will address those. She's known as the Queen of Expungement. She's been doing it for over 20 years. As the first panel mentioned, she is one of the leaders in this area, and we have her here for you tonight. In addition, we have attorney Robin McCoy, who you also heard from, and you're going to hear from her again because she is a practitioner and she's been doing this for about 7 years. We have attorney Rita White, who is also the president of the Black Women's Lawyers Association. She's a criminal attorney, and she too has been doing criminal expungement for years. And we have attorney Stuart Freeman, who is known as the in expungement. He knows all of this stuff. So this is the panel. Community, keep your questions coming in the chat. I'm gonna continue to direct them to our moderators, who will direct them to our panels, and we're gonna get them answered. Without further ado, I turn it back over to our two moderators, Ms. Tanisha Davis and Ms. Zanita Clifford. Thank you.
Awesome. Zanita, you can start off with this panel since I ended on the last panel, and then I'll take it from you.
Okay, so I'll start with Robin. I have a question to you, Robin. What are some of the challenges that lawyers are anticipating with the new law?
I think that I would say, well, I guess I can talk about some of the challenges I saw from just the prior law, like some of the difficulties I've had, and I mean, Stuart can probably speak to this and Rita as well, is just some basic things, making sure people get their fingerprinting. You know, I'm almost like, man, make sure they get their fingerprinting, getting all their information together so that we can do the actual application though. So those are some of the challenges that I experienced before. That's where we were having some delays. And now going forward, you have these new laws. And when you look at the statutes, they have actually added some laws that they've made some things that you can't get expunged that you previously could get expunged. And so that's a problem. I think, I know I asked some of the state reps to stay on, or State Senator Moss, because to wait 7 years, again, that's where we want to speak to them about the rationale behind waiting 7 years for the second felony. Because again, I've been practicing, this is going into 20 years for me. It's 20 as a criminal defense attorney, 20 years for Rita. Rita's been a prosecutor and a defense attorney, so she's had that dual experience. And you see a lot of people, they don't just get one offense. They get 3 delivering, manufacturing marijuana, cocaine, or heroin. And so it's 3 or 4. So it makes it difficult. I mean, it's good that you can now expunge up to 3 felonies. And, I know from the presentation that we watched, I know Stuart was on there with Margaret Rubin. We sent some of that information out. It's more expansive with the misdemeanors. But it's just making, like even with that presentation, they were talking about this new legislation can be somewhat confounding to lawyers. So for lay people, I could imagine, so it's going to even be harder. So that's why I know Judge Thomas is going to talk about this. We're going to need to do this more, where we have dialogue with the lawyers, training more lawyers, getting more lawyers to be on board, having some lawyers that work for the big firms. Maybe they can agree to do expungement clinics, so we can get more people, like Representative LeGrand was talking about at U of M, that they've only had 6% of people who are eligible actually getting expungements. So we want to make sure we can get more people to get their records expunged, make sure that we get, for those of us that are public interest, get more funding available so that we can do more of these expungements for people.
Okay. Awesome. I'm sorry. I'm going to direct this question back to you, Robin. You mentioned that there was some things that previously was expungible in the first statute, but it's no longer expungible with these new amendments. Can you speak to what those are specifically?
There are, let's see, because it's specifically listed in here. I know that I can say directly, obviously, there's the traffic offenses are now expungible that were not expungible before. But okay, like a crime of, they said something about embezzlement. There was something like a crime of theft, that was something that could not be expunged. And they said you can only have up to 2 assaultive offenses. So you can have up to 2, but they're restricting that. And so that's a problem. And then when they're saying you can't have 2 offenses, 10 offenses that are 10 years or longer of the same offense. Again, you have, and I've talked to some of the state reps that are even on this panel, like, other states like Illinois, when they legalized marijuana, they got rid of some of the marijuana laws. And yes, we are more expansive in some ways here, like with the misdemeanors, but people they have a lot of convictions for delivery and manufacturing of marijuana, and you can only get up to 3, and it's usually going to be 20-year offenses. So it's going to be 4, 5 when they're young and they're hanging with the wrong crowd. It's going to be 4 and 5. So, I mean, Judge Thomas can speak to this too, is like when we do these forums, we have a lot of people coming to the forum. Then they'll call us afterwards, and then a lot of people have not been eligible. Yes, this is good, and this statute is making some people more eligible, but there's still going to be a lot of brothers, a lot of young brothers that have like 4 or 5 felonies that are only going to be able to get up to 3 expunged, and it can't be the same offense. And a lot of times they're charged, it's the same offense. And it's just, you go out, like if you go out, you see Michigan has legalized marijuana. So it's like everywhere, everybody's selling marijuana, but you got a lot of Black folk and poor people, poor white people, poor people who are locked up right now that are in jail or prison. And they're still being oppressed by the prison industrial complex. So, yes.
I want to speak on some of what Robin just said in terms of sometimes, okay, I have been doing expungement forums for like 25 years, and this is the 3rd amendment of the statute for me. And when Representative DeLego said, I said this wouldn't happen. No, what I said was, I'm not getting excited till it does happen. Because I've been on this battlefield for 25 years, and it's been up and down. What it appears from my perspective is basically what the representative said. It's kind of like that game show. Everybody got a shopping cart, and you run through and you pull everything off the shelf that you can get, and then at the end of your time period, they total up and see who got the most value. And then when you get it home, you figure out what you got. And that's basically how it appears. You may be able to expunge some of the offenses under one statute, but not the other. And so what really is going to be most complicated is you do have to gather more information. You have to you can't send people to iChat alone anymore. You have to make sure that they also get their record from the Secretary of State. They may have to go to specific district courts. And so the more information is going to have to be gathered, and that is going to be a difficulty. And then it's very data driven. And so you have to eliminate, okay, they may fit under this statute, but it might be better to fit under that statute. That's going to be more time consuming. The forms that I've done over the years were always done in a format of a teacher, because I am a teacher. And the process was to teach people as best as possible how to do their own expungements, understanding that people do not have money to pay lawyers. And I always apologize to the lawyers. I was in private practice. I understand we got bills to pay too. But under this new format, because it is so complicated, I don't think that it's going to be possible to conduct forums where we teach people which one of these 3 statutes might be best for you and how to coordinate. Also, the definition of terms. Some definition of terms we use are going to be in the criminal code. Some are going to be in the parole qualification code. Some of them are going to be traffic code, and some are going to be in the new statute itself. So once again, it's increasingly complicated. The whole thing about the restitution for me is rather confusing. Once we have sentenced a person, the court has lost jurisdiction unless the individual does petition the trial court for the expungement. So, and in most cases, if a case is closed out and restitution has not been paid, then the court is going to say, well, civil litigation. And that the victim has an opportunity to sue under civil litigation. And so that is rather confusing as well. I'm glad there's been some changes. There may be more, the one bad night, because I do a lot of the auto theft cases. That's going to be complicated if you have a situation where the person actually stole the vehicle, perhaps in Wayne County, drove over to Oakland County, and 5 hours later, they were spotted by the police in Oakland County, did a fleeting and a looting, and got receiving and concealing in Oakland County in a 5-hour time span for a vehicle that was proven they stole in Wayne County. So you'll have to, it's all one criminal act. So no, you go to Oakland County for 2 and then come back to Wayne County for the other charge. And then are we going to have forms? You know, and who will have input, and then judicial training. The repercussions of having a felony and how that has generational impact. Families are taking money that they could be storing for education for the grandchild and helping to support the child because the child can't get a job because they have a felony. The generational economic impact, social impact has always torn at me. But when do we educate the judges? Because if a person files an application, the judge is going to have to determine, did they file it under the right statute? Did they meet the different legal definitions? Mm-hmm. Have they met the standard? And so I think it's critically important that the judges are trained on these new statutes. And then if the Secretary of State is going to file, not the Secretary of State, if the Attorney General office is going to file an objection, I think it should be very specific so that the judge doesn't spend hours trying to figure out, okay, well, which part of what are you objecting to? Wrong statute, wrong definition? It's going to be quite complicated from where I sit. From when I began, you could only have one felony and you could not have, or one misdemeanor, and you couldn't have any other convictions, not even for not cutting your grass on a city ordinance. So yes, we've come a long way, but that more people are going to either need to have money to pay a lawyer to figure this out. It's going to take the lawyers more time, so they're going to charge more money to figure it out. Or we're going to have to start looking for grants in order to host clinics where lawyers will represent. Clean Slate Detroit. I would like to see that duplicated across the state. So I'm out.
Judge, I cannot, I mean, that was awesome. I mean, queen of the expungement, that's all I'll say, is that those are the kind of responses that we're looking for too, in terms of how difficult this may be. And so I certainly appreciate, and I know everybody on here, community as well, appreciate your responses to that, because it does seem like we are going to have some concerns, some issues that we have to work through. Zanita, do you want to take the next question?
Yeah. Yes, I'll take next one. So this one's to Mr. Freeman. We have several questions about this. Can you briefly talk about the law, like the process of expungement? What do a person have to do to file for a petition to set aside?
Well, the first thing you do is you file a form motion when the state court administrator's office finally develops it, because they are panicking over this as well. I talked to them this morning to try to see if I could get a draft version out of them. And the answer was they didn't have anything they wanted to be remotely seen by the public yet. When you do that, you get your fingerprints taken and you mail that with a check to the state police so that they can do a criminal background check and the Attorney General can send one of those incomprehensible letters to the judge. After that, you're going to schedule a hearing date with the judge. I usually encourage people to file a packet at this point with the court. It's showing all of the evidence of their rehabilitation, reference letters, college degrees, And while not legally required, I encourage people to also show how the criminal record has gotten in their way. My personal opinion is that a criminal record is sort of like a cancer. Well, you've got it, at best you can hope for is remission, but it will rear its ugly head. You schedule a hearing again, and you appear in front of the judge. Now, with this new law, I think people are going to need to do some checking from these fairs, from talking with others, whether this is a job you can do yourself or whether this is one where you're going to need to have counsel, because frankly, there are still questions in this law that are unknown, and there are going to be some appeals. And I don't know how the attitude of a given prosecutor's office is, but even when the prosecutor is favorable to you, I've seen the attorney general or the state police still come in and try to fight it. And I think the judges alluded to some of them. I appreciate what this law is, but there are still a lot of unanswered questions. Hope that helps.
Thank you. Thank you so much. Are there any more questions in the chat? I just want to check really quickly.
Well, I have something to say regarding this new expungement law. The first thing I would like to say is our people may cherish for lack of knowledge. When it comes to expungement, I look at, we need to start working at the ground in terms of really not even having to get through this really complicated process of trying to get these matters expunged. As a defense attorney, what I focus on is my issue in my head when I'm representing clients is collateral consequences, collateral consequences. A lot of times, several times, sometimes I don't. I get a lot of offers from the prosecutor's office that they don't really, some don't focus on the potential of an expungement. They focus on the information, and then they give an offer that clearly it's not expungible. So in my head, when I start representing a person, an individual, I focus on is we're going to look at plea negotiations. How is this actual plea offer going to wipe clean slate their actual record? So what I do is focus on that issue, because as we see, this new expungement law, you see that the previous expungement law allowed 2 misdemeanors and then pretty much a felony. If it was a life offense or a CSC, it's not expungible, or a traffic DUI. However, anything under life usually is somewhat can be expungible. So what I look at is with these type of matters, we need to make sure we work, and it needs to be a universal goal that the judges, the attorneys, and the actual litigants are aware of the actual law and understand what they're getting into, because there's a lot of loopholes that people fall into because they don't know what's going to happen in the end that's going to be permanent. So when we're looking at this new expungement law, I think we all need to be very, very knowledgeable and educated of this law. And in terms of that way, there needs to be more education and there needs to be more resources. I think the state bar or a public entity needs to put together an actual, populate a list of attorneys that these litigants can look to for resources and information regarding how can they make sure they avoid, or how can they expunge their records when it ultimately comes to a conviction. And we don't have that. We don't have a list on the state bar website of attorneys that show a list of attorneys that these litigants can go to. Because unfortunately, that's a big reason why a lot of litigants fall through the cracks, because they don't have the understanding of who to turn to understand the actual expungement law. So with this law, there are several limitations, but there are several positives. What I look at is in terms of the DUI, all we know is that they're not expungible. However, I think how the legislation is, unfortunately, it has been based on a very political boundaries that's mainly been the way to get things passed. And what I look at is that we could just take apart the political aspect and focus on the person, the human. We can look at the situation that maybe you can consider a person with an OWI from 30 years ago, that they can prove the fact that from 30 years to now, they have not committed any drunk driving cases. They've been able to build up their repertoire to show that they've taken classes. They've never, basically they've been in AA. They've done everything to swipe away that past. Like issues like that really need to be re-reviewed, because I don't think based on just one rubber stamp of a DUI, given the fact that maybe it occurred 50 years ago, and you have proof that a judge, again, all expungements, mainly these type of expungements, are in the court's discretion. And that's what attorneys are required to present. What has this person done from the closing of their probation or their discharge of prison with discharge of parole? What have they done to better themselves? As we see, I'll shorten this up pretty quick, but as we see, the purpose of the criminal justice system is to, a person gets convicted, what is the next avenue? To put them in a program to get them help, to help them actually rectify their situation. It's not just to be the death penalty and put them to death, because we don't have that in Michigan. It's to get them help so they won't be a recidivist. And with that, I think everyone needs to have a chance. And I think we do really need to look more at this expungement law and understand it needs to be done on a person-to-person basis, because all these stories are very different. Some people may have DUIs. And again, as Yancey said, people don't get caught. They'll do it 100 times and then they get caught. But there are some people that actually really work to better themselves. And I think that needs to be presented, and I think they need to be given a chance. So I think with all these matters, we need to always look at the collateral consequences and have attorneys that are at the ground representing these people and knowing before they're even convicted, what do I do to make sure, or what can I do to make sure they have an opportunity to actually remove all of these convictions from their record.
Awesome. That was great. Great response, Rita. I'm going to take one question out of the chat for any of the panelists. There were some restrictions on the old statute regarding how often a person can apply for expungements. Are there similar restrictions on the amended statute that if, for example, if a person's application is denied because maybe they applied under the wrong statute or something small, will they be able to reapply, or is there a waiting period still with the new statute? And anybody can chime in.
I was, sorry.
So I think Stuart, because now you can kind of getting into the practice of law here, which judges kind of skirt that line. But I do know that there that you can reapply, and I'm kind of hesitant on as to where to go. I've always advised that if it looks like it's not going to be granted, the petitioner should withdraw their application before the judge can give the denial. And then you don't have to worry about, can I reapply? You file the petition, you can withdraw the petition. There was indication in the statute that I did see that indicated that you not only could you reapply, but that you can apply more than once under the different statutes to different courts as necessary, which to some extent was available also under the old statute. But I'm not going to practice law here.
And I saw there was a reference to 3 years, but I want to defer to Stewart, Attorney Friedman.
I was busy checking through my cheat sheet and wasn't finding it, but that was my recollection as well. But even under the current law, the trial judge can deny a motion and lift the ban on reapplication. They can specifically authorize one to be filed in a lesser period of time. And the classic case would be a situation where there was missing data. I had one where the person had a marijuana charge out of Canada and they couldn't figure out what was going on. And the judge ultimately just said, it's denied without prejudice, you can come back. And when I got a statement from the RCMP that it was under a diversionary statute and there never was a conviction, it was granted.
Also, you can also ask for a continuance and adjournment in order to gain more information or to be able to present the information that the judge may be looking for. So as an attorney, you know this, but as lay people, they may not. But you can always ask for a continuance. You can always ask that the matter be adjourned in order to provide the additional information. I think it's important too, that when you go before the judge, that there seems to be some misunderstanding as to what is the standard, not the standard of proof, with what it is you have to show the judge. And the law has always been that you have given back to society. And under the new statute, it's my understanding that it's kind of like a question of it's in the best interest of society. So I've always informed people that getting a high school diploma, getting married, having kids, buying a house, all of that was for you, the individual. It was not for the benefit of society. And so that you need to be able to show that you have given back to society through volunteer service, something of this nature, something that was good for the community. And I don't think there's been a change in that standard from what I have seen so far. I mean, it's always wonderful if you've been able to finish your education and things of this nature, but you need to step beyond yourself and what have you done for the benefit of the community. And when you make your proofs before the court as well.
Right. And I would say if you have some judges that are progressive, they will let you know, when you do the application, you'll get a response from the Attorney General. That's one way if they have objections, then you can withdraw your application to address whatever the Attorney General, what they have to say, or write a brief or a response to what they have to say. But you have some judges that may alert you and say, okay, Attorney McCoy, you may want to withdraw this. There's an issue here. I have seen, as I've done these workshops, there are judges that have said to me, they do want to help people get their records set aside, but they need to have statutes out there that will permit them to do it. And as we were talking about this last year when we were doing forums and we were including the state reps, state senators, I also reached out to the governor's office, and because one of the things that we also talk about is pardons. Under Governor Granholm, they had pardons. There are other governors. You've had governors that have done like 1,200 pardons. And so I did reach out to our Governor Whitmer's office last year, and I was told that we wanted to see what happened with this clean slate legislation, which is a good start, but we still have I have people calling me all the time that are not going to be eligible. So then that's where we want to ask the governor's office, are they going to open up is she going to do mass pardons like what's been done in other states? Because we often have people, it's been 20, I got a list of people, 20, 30 years, they only have 2 offenses or 3 offenses. I have a lady now, I'm trying to help her. I know that there was initial question about some of the difficulties. It was back in the 70s. I'm trying to help her, but one of them, the court building had a problem. So we're going to have to get a letter because the records were destroyed. So you have difficulties like that, where if they have such an old record, I have one person, I looked for something for them in Benton Harbor. We couldn't find a record those are some of the difficulties that if you have really old cases, to me, it's a no-brainer. Like we've all said, the representatives, the attorneys, when you make a mistake, you pay your debt to society. You should be able to redeem yourself, get your record cleared, get a job, get adequate housing. But because of the way the laws have been in Michigan, they've been so punitive, it's like a life sentence. And for drunk driving, for the issue for drunk driving, a person could be, it's like marijuana, or even before, you could have 7-4-11, that's diversion for possession of cocaine, possession of heroin. But for drunk driving, I know that they've said Mothers Against Drunk Driving, they have had a very big, strong lobby. And I'm not saying that they shouldn't have a big lobby for people who are multiple offenders. But if you had somebody that had a drunk driving and it's been 20 or 30 years, and they haven't shown a pattern. I mean, because those of us are defense attorneys, we see the pattern, or the judges too. You see the pattern where you got somebody 3, 4, 5 drunk driving. Okay, they got a problem. But somebody that has 1, and then you have some of those crazy cases where a person is sitting in their car and the keys in the ignition and they get tagged for drunk driving. The car is not moving. I had a young college student that had that experience. So we do need to, these new statutes, it's a start. But we need to really, because these are people's lives. People are being affected. I see people every day. Like Attorney White had said, as we do more of these expungement forums, as Judge Thomas, has had us go around and you learn about how people are affected. That does affect you. You want to get a defense attorney that is going to be informed by that, that's going to try to go in and try to get your charges dismissed or try to get the most charge reductions. And you also, we've had elections with prosecutors. We have Ellie Savitt in Washtenaw County and Karen McDonald. We want to promote more progressive prosecutors. Some of you attorneys that are upset may need to run for prosecutor or put pressure on the existing prosecutors to be more compassionate. Yes, you commit a crime. Yes, you should, look, if I did something when I was younger, my mama, she was the police, she handled it, but she still loved me. I had redemption. So it's like, we need to have that with everybody else too. Give people a chance.
That is
Can
so
I jump in?
Go
Sorry.
ahead. Absolutely.
On pardons, I am one of the pardons from Governor Granholm. I was a punk, was involved in a car theft ring. I had 5 felony convictions. Law is actually one of the professions where you can get into with a record because of the Occupational Licensing for Former Offenders Act. I think Representative Moss touched on it a little bit, but I did as well as anybody could have done with a record. As I said, the cancer was in remission, but the day I got the pardon, I literally ran 5 miles, and while I was running at the time, that was about 2.5 miles more than my record. It makes a huge difference even when you're moving ahead. But what I wanted to also talk about is, because records are lost, because a lot of the things you do that are good in life, you don't keep records of. You really need to think about that really from the day of sentencing. Create a folder, put everything that you do that's good in your life in that folder, put all the documents from your criminal record into the folder. I actually went to prison. This was back in 1980, and the Department of Corrections called me to find out what I had left in my inmate file because they had no file on me. Think about that. For misdemeanors, the record retention period on files is 6 years. It's longer, but transcripts are only 12 or 13 years. And you have a lot of fights over those things, and you waste a whole lot of time and legal money when you sit there and have to reconstruct things as best you can years later. So start early.
I do agree with what you're saying. Oftentimes, crime is highest where poverty is highest. Where poverty is highest, people are most mobile in their living. And so it's sometimes very difficult for them to retain records because they're moving in the middle of the night before things are set out on the street, or they stayed until things were set out on the street, and then they didn't have any choice. And then the educational level, sometimes it's very difficult in the retention of the records as well. But I do see where that is going to be an issue in some of these applications for expungement. How many courthouses have burned down? Okay, and you can't duplicate the record. You put forth the best argument that you have. And even if you didn't keep proof that you gave 150 hours of community service, somebody over there remembers you. And if you know you're going to go for an expungement in another year, 2 years, 3 years, okay, go do something now. So that when you make your application in 2 or 3 years, you've got recent information. I'm looking for clarity on this automatic expungement, because which I'm not taking a position of opposition or anything else. I'm just looking at it from a judge's perspective. What standard? Just a lapse of time? Is that sufficient? Are they going to be subject to review? I saw in the bill that the prosecutors may be able to object, that the attorney general may be able to object. So then there's got to be a review process if there's an objection filed. So there's still some confusion as to the judicial input on automatic. I thought it was automatically filed, not necessarily automatically given. And if that's the case, then is there going to be a judicial backlog? Are we going to overwhelm the courts? Because in 2 years, when this goes into effect, are we going to get hit with 10,000 cases in 1 month? I have some questions in that regard as well.
Excellent questions as well, Judge. That was one of my biggest takeaways from reading the statute, was just how the automatic expungement process was going to work. And it sounds as if it is going to overburden a lot of the courts.
And if you have a conviction before more than one judge, all right, there's always been, if you, one lawyer per client, if you got 2 or 3 cases pending at the same time, you shouldn't have 2 or 3 attorneys. We try to have 1 judge per client, but you may have a conviction in front of me on a case, and then 4 or 5 years later, you may have gotten a conviction under another judge. So then you file 2 separate applications, even if they're in the same courthouse?
That issue came up in the criminal defense attorney seminar. We combed over it. We think you can all file it in one, if it's in the same court, Wayne County Circuit Court, not say 36th District Court and Wayne County Circuit Court, in front of 1 judge. And that's obviously going to raise issues about forum selection and
yeah, which one judge?
Yeah, the first case, the best judge, what?
Yeah, which one judge? And then again, with that one bad night. Okay, so if you're successful in the Oakland County where you had the receiving and concealing, fleeting and eluding, do you bring that expungement to the Wayne County where the auto theft charge originated, larceny over $10,000, $20,000, and you say, well, it was all that one bad night. I got it over here in Oakland, so I should automatically get it here in Detroit because it was all one bad night. How are we going to handle those things?
How do you define a transaction too?
Right, and there was a question in the chat about arson. Can that be expunged? My understanding, if it's 1st degree arson, it's a life offense, that can't necessarily be expunged. But I don't want to. Can Judge or Attorney Friedman speak to those? If arson, have you seen that?
Life offenses are not expungible.
Not expungible.
And neither are attempt life offenses.
Right.
So it may depend on the degree of arson, because there's more than 1 degree.
Right. So that's, yeah. And yeah, again, that's why it is very important for people, as I said, as I do the workshops, it's very important when you have you get it, if you catch a case. Well, first of all, that's why I do, I do the what to do when stopped by the police, for you to avoid catching the case. Don't hang with the wrong crowd, okay, while you're playing. But if you do catch a case, you want to be very mindful of what you plead to, because you've had, the prior prosecutor's office in Washtenaw County, they could be very restrictive at times, and they would charge people with 2 felonies. And they knew that the statute was 1 felony and 2 misdemeanor. And so, I mean, even sometimes in Wayne County. So, and they knew it was going to be restrictive, but then people are scared. People don't want to, they're like, okay, I'll take the 2 felonies because I'm promised probation, not understanding that, but you're not, under the old statute, when it was 1 felony and 2 misdemeanors, you were not going to be eligible for expungement. And now, if depending on your offenses, you may be eligible. But to me, it goes back to the prosecuting. Who is the prosecutor? Making sure we have progressive prosecutors, balancing. It has to be a balance. They have to do their job, protect the public, but also make sure that a person doesn't have a death sentence. We don't have, like Attorney White said, Michigan does not have death penalty. So, but we have some laws in Michigan that operate like that for people, and it disproportionately Black and brown, indigent folk, working class folk. So it's just not cool. I do see, I want to give a shout out. I saw Judge Carol Conkey was on there, the chief judge for Washtenaw County. And I will be circling to Washtenaw because I'm from Washtenaw originally. So don't think we not, Washtenaw, state reps, state senators, we're coming your way too. Because I look at this, as I said, I'm a college professor, I teach, this is a class, we're the students, we're trying to learn this so we can help people, help. I became a lawyer. Yeah, I became a lawyer. I decided at 14, I want to be a lawyer to help people that are in the system, brothers in the system, and now sisters, and as I said, everybody. So, hey.
This came up in with the state reps, and it has left me confused. And I believe in education, so somebody educate me. My understanding of the law in the state of Michigan is that we do not have cash only bonds. That the law in the state of Michigan currently does not allow cash only bonds. That it has to be at least cash surety or cash 10%, but Michigan law does not allow cash only bonds. Did the law change and nobody sent me the memo?
No.
Thank you. So I think so. If you're going to
cash or surety, but not cash only.
Thank you. But if you're going to make the argument, which even tonight was being made, that Michigan should not have cash only bonds, we don't have cash only bonds. So it's kind of like you got to choose your wording. Whatever the issue is that you have, you don't want cash surety because some people don't own houses. There are bonding companies that will take that fur coat, that diamond ring, that automobile. Okay. But it's already unconstitutional. It's not against the law in the state of Michigan, even though I will admit that I have received cases from some district courts that have cash only bonds. Well, that's not a legal problem. That's a representation problem. But so those who are behind this no cash only bonds, Michigan doesn't have cash only bonds. Thank you very much.
And I see Judge Conkey has put in the chat, she said, Washtenaw is here. We are doing bond/no bond. Ability to pay is not the issue. So shout out to Judge Conkey for sharing that information with us.
No, it ought to be.
Oh, there you are. Okay, I see you.
So I think in terms of
We're going to criminalize poverty. Is that what we're doing? Nope.
Michigan already, the law in Michigan currently is that you cannot have a cash only bond. So how
about no cash bond? How about if you are too
only
to be out, then you're in?
The no bond, as I understand it, is only permissible when you're looking at, say, life offenses, where you can say, you can do $1 million bond if you're looking at a murder one, something of that nature. But just on your lesser offenses, and I know 22 years is a long time, but even in your lesser offenses, you cannot give a cash only bond. The law allows for a remand on certain specific offenses, such as your homicides.
Thank you, Judge.
Go ahead. Of, what a person can do to make themselves more likely to be eligible to have their record expunged. This is like kind of a very, very wide, broad kind of topic, because as we know, as us practicing attorneys and judges, people in the legal field, we know that there are a large, probably larger than normal percentage of individuals that are convicted that suffer from serious mental illness or medium level mental illnesses. I think we've made some very good strides in putting together many services and options that people can take advantage of to avoid a criminal record. So it's kind of a pseudo pre-conviction expungement. We have Judge Deborah Thomas here, who pretty much started the Veterans Court. And that is an opportunity to help people rehabilitate themselves. We already know a lot of people commit crimes because they have a lot in their past that they've grown into that creates a lot of issues with them, mental PTSD as former veterans. We have a lot of people that have issues, but when we come to court, it's wiped away. It's just the person and what did they do. I handle juvenile cases where I see juveniles in court, they commit fleeing and eluding, et cetera, et cetera. 5 years later, I see them in the adult court. Why? Because this is their life. This is what they've grown around. This is their environment. They may have suffered also from mental health conditions. So what we need to also look at is how can you make sure you rehabilitate yourself, even if you do have a conviction. As Judge Thomas has indicated, she has veterans court. What happens when someone's convicted? You get sentenced. You be ordered to take a class. You be ordered to have a psychological evaluation. You be ordered to do community service. These are all rehabilitative matters that you can take upon yourself. When you have a conviction, take it upon yourself to do this, because you have to provide this to prove that you are a person that will not be a recidivist. So I think there's issues that we really need to work on to make sure we just cover the whole perspective. And I really think this needs to be a person-to-person situation when we're evaluating a person eligible for expungement. Because we have a lot of people, again, that are brought into the system because they grew into the system from their family, from their environment. So over and above the actual statute that's been put to place, we need to focus on how can we avoid, regardless of the expungement statute, these individuals coming back into the system. And that will help eradicate the number of people disproportionately, people of color, people that have mental illness that is not caught, to avoid and slow down the progression of the criminal system building more and more.
Thank you, Madam President. And Judge Conkey, I know since you've joined us, well, I know you've been on for a while, and as I said, I'm going to be circling back to Washtenaw probably in March or April, but did you have any input? Have you had the opportunity to look at the new expungement laws from your perspective as a judge about the way it is or implementation?
I've seen it come before me a few times when people are, I would say, jumping the gun, but that's not really right. Like they're asking for what they should have been entitled to a long time ago. What I have done many times is tell folks under the old laws, look, you're not eligible yet. How about you withdraw your petition because you can't bring it again. So let's keep that eligibility. I think that there is a lot of uncertainty and questions in the bar and in the public about what the laws will do for folks. And I'm so glad that there are people who are interested and motivated to find out what is available and to really just like get out there and do it, because criminalizing a person's entire life is so bad. It's bad for the person, it's bad for society, it's bad for everybody. We should all care about the fact that people are it's that scarlet letter that keeps you from getting a job and getting, all the things we've talked about tonight.
Right. So we're about to be at 8, and you guys have been wonderful. I want to thank our wonderful panel and our moderators, Danita and Tanisha. Thank you for stepping up. And our planning committee, Chandrika, who's been helping us with tech support, and Angela Jackson, who's on the planning committee, and Attorney Rita White, our Madam President. And I'm going to turn it back to Madam President to give us closing remarks, and stay tuned for more programming. I have my YouTube show, Robin Legal. I have Political Coffee with Tracy. Chandrika has her platforms on social media. And I'll be roping Madam President Rita White into some of my stuff too, so to do some programs, so you'll see her. So thank you for the awesome panel, and I'll turn it over to Madam President White.
Yeah, some notes to take away from this presentation that has been very good. We've learned a lot from the state representatives. We've heard a lot. We've gained a lot of information from this presentation. But one thing I would really encourage all of you, lawyer, not lawyer, anybody, to look up MCL 780.621. That is MCL 780.621. That is the statute that is going to be in effect. And the new conditions of that statute will be in effect in April 2021. Read those, understand them. You may have to read them about 50 times because they are a little confusing, as I've read them 10 times and I'm still trying to figure them out. But it's important because we really need to make sure we take a hold of this issue. We have too many people that fall through the fall through the cracks because they don't understand what they're dealing with, what offer they're getting, what they're being convicted of. So I would just advise you to do everything you can to make sure you're knowledgeable, and if you know anyone that's dealing with a prior conviction that might need help, talk to them, help them understand the process so the attorney and the client can work together to make sure they have a clean slate. So I thank you all for coming. And if you have any questions, feel free to reach out to our website, any of our attorneys that have left their contact information, and the legislators who've been very just a work of progress for this whole matter. Stuart Friedman, I've worked with him and he's very knowledgeable. So we're not just here to have one meeting. We're here to keep the process going. Knowledge is everything. So let's just keep it going. We're not afraid. Contact us if you have any questions, and let's just keep this moving in a forward positive manner. Thank you so much.
Thank you. Thank you, everyone. Have a blessed evening.
Thank you.
Thank you.